Hey there, how's it going? My name's Christian with Plan Your Federal Retirement. And if you've ever wondered what's the difference between a will and a trust, what are some of the pros and cons, which option's going to make the most sense for you, then hopefully after the end of this video, you'll feel a little bit better about that. So I'm a financial planner, and we look at things, especially when it comes to estate planning, from that financial lens, from that tax lens. And the legal disclaimer here is I'm not an estate planning attorney. So I'm not licensed with the bar. I'm not the one drafting these documents, right? So if you have questions on this, make sure you are seeking that counsel from an estate planning attorney who can then draft these documents for you. But I am able to help clients at least educate them on the differences between those documents. And hopefully today in our video, we'll go through some of those pros and cons just briefly. And you can start to think about, based on your unique situation, which one might make the most sense. Both the will and the trust attempt to get to the same place at the end of the day, to guide where your assets are going to go at the event that you passed away. How they do that is going to be slightly different. So the order of operations when someone passes away is first that things transfer by title, however they are titled. So think about, the house, or think about a car, right? If you have single title to that, individual title to that, or if you have joint title, then however it's titled, then that asset would transfer just how based on that asset is titled. Next on the list would be beneficiary designation. This is why we talk so much about making sure all of your beneficiary designations within the FERS system, including the TSP, including your last paycheck, including your FERS pension, all of those beneficiary designations are accurate and up to date. Make sure you have a contingent beneficiary listed there as well, because regardless of however a will is stated or a trust, the beneficiary designation takes precedence. And so that beneficiary designation is that important. So it guides where that asset goes. You can have beneficiary designations. Think about, the TSP. Think about retirement accounts, life insurance. Some states even offer a transfer on death deed. So we can have that as a part of the deed in some states. There's payable on death accounts as well. So those are going to guide where your stuff goes. Really, everything that's left over, that's what then would go through probate. A will, the last will and testament, guides the probate process. Now, remember, the probate process is a public process. So none of this information would be hidden to the public. It's all a public process. And for some people who want to have a little bit of privacy, this is where the downside of just having a will can come into play. If you don't want to have all of our stuff open to the public, then this is going to be maybe not the best option for you. The will, again, guides that probate process, and it tends to take a little bit long depending on what state that you're in. Some states, it's a little bit more expensive as well. So the probate process a lot of times is not fun for some states. Some states, it's a little bit more streamlined, a little bit cheaper, so it might not be as bad of a word in some of those states. You're just going to want to see, based on where you live, how that probate process works. So the will, you appoint, an executor. They help guide that process. You're going to work with an attorney. And overall, that process could take several months, maybe even up to a year, and to settle your estate using a will. So if you've done things correctly and you have proper titling on your assets, maybe you have a transfer on death deed on some of those assets that you have, like the house, maybe you have all those beneficiaries lined up. If you've done a good job on titling and on beneficiary designations, there might not be a whole lot left over that would then go through probate, right? So the will just is a catch-all for everything else that we didn't have title or beneficiary designations on. Another way to look at it is to use a trust. Now, the trust is a separate document that we create that's a private document. And what the trust is, how I like to think about it, is it's almost like its own entity. It's almost like its own person, where you, the person creating this trust, become the trustee. And if you have a spouse, maybe you have one trust. Some states or some attorneys like to have one trust per spouse. I've seen where it's a joint trust, like I have with my wife. However it's designed, the trust essentially becomes its own person. And inside that trust while you're alive, if we're talking about a revocable living trust, you can decide how your assets are going to transfer and at what ages. One of the things I like about a trust is it gives us a little bit more control, a little bit more control from the grave on where our assets go. If we go back to the will, or if we go back to just a beneficiary designation, if we named our kids as beneficiary on our accounts and they receive the money, we can't decide later that, oh, I only wanted them to get half now and the other half, 15 years from now. You can't do that with beneficiary designations, or we can't do that with just the probate process. Whereas when we create a trust, we have a little bit more control there. Or maybe there's other special considerations there, like special needs in our family that we're wanting to protect certain assets from somebody receiving certain assets that might disqualify them for aid that they're receiving. Or maybe there's mental health problems there, or maybe there's substance abuse problems. There are spendthrift problems that we can create and have a little bit more control inside of the trust. That's one of the benefits of a trust. I would say if you've got property in multiple states, when we use a trust, we can avoid probate. And that's really the goal when we use a trust, is to avoid having to go through probate when we use the trust. Especially if you've got property, let's say in multiple different states, there might be multiple different probates that we'd have to go through. Whereas if we just have the trust and it's properly designed and our assets are pointing towards the trust, then we can avoid probate, which helps our loved ones after we've passed. When it comes to the trust, there's a little bit more upfront work that we have to do. We want to think about transferring title to the name of the trust. We want to make sure that our beneficiary designations that we have are going to point towards the trust. This is where you're going to really want to work with your attorney if we're thinking about utilizing a trust to make sure how we are going to fund the trust. Just because we create a trust doesn't mean that our assets are actually going to be in the name of the trust when we die or right now. So we want to make sure that it's properly funded through proper titling, proper beneficiary designations, and then inside of that, how is it designed for that money to go to the people that we care about? So I know I've talked a lot about trusts here this last little bit, but I wanted to go through it because it becomes a little bit more complex and there's a little bit more pros with it, there's a little bit more complexity with it. There are also some more downsides. Trusts tend to be a little bit more expensive, a little bit more of an upfront cost. Whereas if we just go with a will in the beginning, that might end up being a little bit less expensive to deal with in the beginning. But when you die, the probate process could also then become expensive. So we're kind of delaying some of those expenses. Again, which option is going to make the most sense for you is really going to be based on your unique situation. Depending on your marital status or depending on your kids, if you have kids and their ages, that's where we're going to have to say, or maybe we have a blended family, that's where we're going to have to say, what's going to be the best tool? And if the will is not sufficient because there's less control there, then that's where we want to possibly lean towards creating that revocable living trust. And so this is kind of the tip of the iceberg with that conversation. So just make sure you're working with a trusted advisors, financial professional, tax professional, estate planning attorney to help you make that best decision moving forward. So hopefully this video was helpful and educational for you. If you have more questions related to this, feel free to leave your question below in the comment section. Make sure you are subscribed to our channel. And of course, until next time, happy planning.